last lab, we talked about the European institutions and how policymaking works in Brussels, but also how those policies then go to the national level, and also how the three main institutions interact with one another. So the Commission, the Parliament, and the Council. And today, we're going to talk about policy, but in the context of seeds. And I try to follow the topics that you really wanted me to talk about. So I'm going to start with the European Green Deal and then go further into biodiversity conservation, then seed marketing legislation, and then a little bit on intellectual property rights. But so if there is anything else that you would want me to build on, please don't hesitate to write it in the chat or to get in touch by email, and we can elaborate on it. Also, for those that know already a lot about seed policy, please know that you also have people who do not know anything about seed policy. And so that's why this presentation wants to cater to a very wide range of knowledge holders. And there are no stupid questions. I really want to reiterate this again, please. So don't hesitate to ask. And now, okay. So we're going to start with the European Green Deal as per your request. So the European Green Deal is, you might remember from the last lab we did. I'm going to use again the graphs that we've developed for that lab, but it is a commission communication. Okay, so communications are non-binding instruments. So they set essentially, they can use different, they can have different functions, but they set political priorities and a vision for a commission, which is nominated for a specific term. And this commission's vision is this European Green Deal, which was presented in December 2019. So 2 months after they actually took office. Okay, so see this as their political priorities. These are non-binding instruments. And the European Green Deal, so it has different elements. So it has a very high climate ambition. It also has an energy component, something on circular economy, energy and resource use efficiently, zero pollution, biodiversity, farm to fork, then mobility, all this by finding tools to finance the transition while leaving no one behind. So having the 3 pillars, okay, of sustainability so environmental, social, and economic. So how does this translate with regards to seeds? As they want to mobilize research and foster innovation, you will have something on intellectual property rights, okay, that relate to seeds. You also have one big flagship initiative that directly impacts seeds, which is the biodiversity strategy post-2020. I'll get to the details of it a bit more, but what you see in the European Green Deal is that it links up to crop diversity through wild relatives, through crop diversification, and it mentions the facilitation of marketing of traditional varieties. Okay, so that's the link that you can make there. And then the most important links come from the farm to fork strategy. Okay, these links are through the common agricultural policy. So because the European Green Deal makes the link that to have more resilience, you need more crop biodiversity. And there is also the target of having much more EU land under organic production conditions. There's also the flagship farm to fork initiative, which is called the Sustainable Food Systems Initiative, which we'll see after a little bit, which views to address the food system in a holistic way. So it goes beyond the classical value chain, and it also looks at consumption patterns, the drivers of unsustainability in the food system, etc. And then also a direct mention of seed security in the farm to fork, leading to a reform of the seed marketing legislation. So how does this fit? Okay, so I'm taking back, so these slides were not circulated to you. We will. I added them today because I wanted to give a bit more context. So you remember this pyramid, I hope, from the first lab, right? So the pyramid is the pyramid of binding instruments in EU law. So you have the EU treaties, then the treaties are translated in regulations and directives of the European Council and the Parliament with the initiative of the European Commission. The Commission then can implement these at EU level through regulations and directives themselves. The European Green Deal is not part of this pyramid, okay, because it is a non-binding instrument. It is a Commission communication. And the three elements that I talked about that relate to seeds in the European Green Deal, well, they're not binding instruments either, okay? The biodiversity strategy is not a binding instrument. The farm to fork strategy is not binding either. And the intellectual property strategy is not binding either. What you have is then, after these strategies, so I forgot to give dates. So the European Green Deal was adopted in December 2019, the biodiversity and farm to fork and the other strategy, so the come in May 2020. Okay, they came later on because it's the translation of the European Green Deal into thematic strategies, but still non-binding strategies. For biodiversity, you have two additional non-binding instruments that have a link with seeds. So the Organic Action Plan and the Forests Action Plan. The only concrete binding instrument that you have that is linked to the biodiversity strategy is the Birds and Habitats Directive. So you see the very far away link that you have with seeds already here. Then for the farm to fork strategy, you see the difference, right? So you have the Organic Action Plan, which is a non-binding instrument that has an impact, but you actually have three big initiatives that directly impact seeds and that are binding. So all the tools of the Common Agricultural Policy, the Sustainable Food Systems Framework, and the seed marketing legislation. And all three of those are binding, okay? And they are linked to the European Green Deal and mentioned in the European Green Deal and the farm to fork strategy. And then you have an intellectual property strategy where you don't even have another communication. So the communication is the strategy itself. And then it again links to binding instruments, which leads me, and those binding instruments are the unitary patent system and the community plant variety rights, which I think you when you see these slides, the first thing you say is, oh, where is EU competence on seeds beyond actually going to looking into the EU common market? When you see the difference between how much action and binding instruments that can be adopted by the EU on biodiversity compared to the actions that they can take on the farm to fork and intellectual property, you see that the founding EU treaties are actually, not used and maybe do not provide, this is interpretation, but do not provide a strong enough legal basis to act on biodiversity, and especially not on seed diversity. But we'll get there. So then we're going to have a closer look on each of these three topics, okay? So biodiversity, conservation, sustainable use, and biopiracy. I'm going to look at international level action, EU action, and then that's it. And then maybe I'll mention national action because that's where the most important part of the binding action comes from. Then seed marketing legislation, where we're going to spend a lot of time because so you wanted also to look into the past reform process. So we're going to look at the history of the legislation, its purpose, its principles, the past reform and maybe talk a little bit about the next reform without going into advocacy, because that's for the next lab. And then talk a little bit about intellectual property rights. Okay, so for biodiversity conservation, you have 3 layers that I want to highlight. The most important layer being international law. Then you have EU strategies, so non-binding instruments, which we lawyers refer to as soft law. So it means like, so it is a legal instrument, but it's not binding because it doesn't have teeth in a way, but it's you can still use them strategically. So you can use strategies strategically when you communicate and advocate for something, for a change in binding legislation. So that's why these tools are important when you're advocating for something that you think needs to change. And then third layer, EU law, like binding instruments. Okay, in terms of international law, what you have is that, so there, with the realization of maybe let's, how do you present this? The impact of human activity on nature and on its ecosystems so during the Rio Earth Summit in the 1990s, where you had the most maybe arguably important international environmental law instruments that were negotiated and signed by a lot of different countries across the globe. There's one convention that is dedicated to biological diversity. Actually, the signatory states are right now negotiating, are meeting and negotiating the next work plan under the convention right now as we speak. And the idea of this instrument, so this is an instrument that is under the premise of the United Nations Environment Program, and it looks at all biological diversity and ecosystems. And the main goal is to reverse the decline of biodiversity and also address something that has been coined biopiracy from the I guess you could say 70s, 80s onwards, which biopiracy, so biological piracy, it was coined by the ETC group, if I'm not mistaken, which is an NGO that looked into the use of biological resources of the global south by usually big companies from the industrialized north without actually paying back, or recognizing the contribution of the global south and the populations therein on the products and the value that was generated to the use of biological resources. Like one of the most infamous cases relates to the neem tree, for instance. Maybe you've heard it from India, which led to a patent at the European level, but also other jurisdictions. So without ever compensating India, and actually the patent was also given through international instances, which made that impossible for the guardians and custodians of the genetic resource and the tree to use it again without paying back royalties. So that's the premise of the Convention on Biological Diversity. And then you have a second instrument when we're talking about seeds, which is equally important. And this one is not under the United Nations Environment Program, but it is under the United Nations Food and Agriculture Organization. Okay, so we're moving from Nairobi and Montreal, because that's where the seat of the Secretariat of the Convention on Biological Diversity is. We're moving to Rome, to the seat of the International Treaty on Plant Genetic Resources for Food and Agriculture. And here, it's not about all biological diversity in ecosystems. We're only talking about genetic resources that are used, so for food, and agriculture, not anything else. And it includes microorganisms, but it's not this ecosystem in general, more holistic approach. So it's a very specialized agreement. And here, obviously, there's this realization that you need to reverse the decline of biodiversity, and it's to reverse the loss. But the idea is also founded on the interdependency that exists across the globe on food and agricultural genetic resources. Meaning that, yes, even though you can say you could probably determine regions of origin of the major food crops, the food and agriculture moves so much and people move so much, and they develop in a different fashion, in a way, even before the globalized market, that there is an interdependency, and you need to use the genetic resources across the globe to actually ensure food security. Okay, so the idea of biopiracy is not as strong, in a way, in the international treaty compared to the Convention on Biological Diversity. And both texts are based on sovereignty, so that also explains why the European Union has less power in these two instances, because the genetic resources are within the sovereignty of states. And so it's European Union member states who have sovereign rights over the use and access to genetic resources. Okay, they both address conservation issues, so they want to make sure that we don't lose either all biological diversity in ecosystems or food and agriculture and genetic resources. So this means you create natural reserves, you zone out certain areas for conservation, or you put genetic resources in gene banks. Okay. What is also interesting, already in the Convention on Biological Diversity in the 1990s, but also the instruments that predate the international treaty, there's this notion of sustainable use. Okay, so the notion that putting things in gene banks and freezers and natural parks is not enough. You need to make sure that they're used and that they're used sustainably. And here I have quoted a very interesting article that is often forgotten in the international treaty when member states talk and negotiate. It's the article on sustainable use. And what is it? So it means that you need to promote the development and maintenance of diverse farming systems, need to strengthen research for the benefit of farmers, promote participatory plant breeding, broadening the genetic base of crops, increase the range of genetic diversity available to farmers, promote the expanded use of local and locally adapted crops, varieties, and underutilized species, review and adjust breeding strategies and regulations, so laws, that concern variety release and seed distribution. So there's a clear link that is made with legislation, right? And seed marketing legislation especially. So states have obligations to ensure that genetic resources are used sustainably at international level. Another thing that I wanted to touch upon is that in the Convention on Biological Diversity, as I said, one of the second goals besides conservation and sustainable use is also biopiracy. So there's this recognition of traditional knowledge held by indigenous and local communities. And what is traditional knowledge? These are innovative and traditional practices and uncodified knowledge that is held by communities and that cannot be used in research and development without their consent and without a sharing of the benefits that arise from the development of products using that knowledge. The same principle also apply with the use of genetic resources. didn't get in there. If you want me to address what we call access and benefit sharing, I'm happy to do it on Friday, but I wanted to avoid migraines. The only thing I wanted to point out here is that you see there's a difference. So there's a mirroring clause in a way in the international treaty, but it relates to traditional knowledge, but it's framed as farmers' rights because you're in a specialized agreement. And here we're talking about farmers and local communities. And the idea is that the states need to promote or support farmers' efforts to manage and conserve on farm their plant genetic resources. And they need to protect the traditional knowledge of these farmers and ensure that they participate in the sharing of benefits that arise from the use of genetic resources, and that nothing in legislation cannot limit, nothing can limit, the right to save, use, and sell farm-safe seeds, subject to national law. 4 words that make it extremely difficult to actually make sure that something concrete happens on that end. Okay, so this is the picture at international law. So how does this translate at EU level? First in soft law, because that's mostly where everything comes from. So it's strategies. For all biological diversity and ecosystems, as I mentioned, we have the EU biodiversity strategy. So I'm focusing on the one that's currently applied. So it's 2020, 2030, but you had biodiversity strategies going back to the signature of the CBD. And that's how the Commission moved the implementation of the conventional biological diversity forward for lack of competence, okay? And the new strategy is called Bringing Back Nature into Our Lives. And here, so you have a lot of targets, okay? And the focus is clearly on the establishment of protected areas for at least 30% of land in Europe and 30% of sea in Europe. Having protected areas for at least 30% of land also means that, you know, indirectly it impacts seeds because there will be a lot of competition for land use for agricultural production, right, at the end of the day. And then there's also a second side to it, which is the restoration of ecosystems that are degraded at land. So increase organic farming and landscape features, halting and reversing the decline of pollinators, which all indirectly, so, and also the targets on the reduction of use and risk of pesticides, but which is very ambitious. And all of these measures indirectly impact, obviously, agricultural production systems in which seeds are the foundation, right? And so also the idea in the strategy is that you get money to do this, you know, that's what the European institutions can do. They don't have much competence, but they can fund things. And so they unlock a big chunk of budget yearly for biodiversity and want to make sure that the EU negotiates and has a leading position to defend essentially the Convention on Biological Diversity. Okay, so play the good guys and make sure that the convention still survives and does things. For food and agricultural genetic resources, in terms of EU strategy, you get crumpets. There's nothing formal at EU level. There were preparatory actions for genetic resources, 2 of them. The first one being actually financed by the European Commission, the second one financed by the European Parliament, but carried out by the European Commission. And nothing happened, not even an action plan, not even like a strategy, nothing. And one of the latest research projects that got money, so from the Horizon Europe program, so which is the research program of the European Commission, actually said you need formal EU action, okay, because it's really crumpets. What the EU biodiversity strategy does, so because you don't have like an ad hoc action plan or a specific strategy for agricultural genetic resources, you need to go fish in the general biodiversity strategy, right? And there was not much in the previous strategies that was really concretely linking to seed legislation. And now there is. And it mirrors what the farm to fork strategy says. And the European Commission commits to take steps to facilitate the registration of plant varieties to ensure easier market access for traditional and locally adapted crop varieties, and then restore land, okay, with high diversity landscape features. So that's where you need to go. There is not much for food and agricultural genetic resources. When it comes to EU law, you have EU level things on conservation. Okay, so the Habitats Directive, the Birds Directive, and so the establishment of Natura 2000 sites. These are directives, so directives are not directly applicable. They need to be transposed at member state level. And so essentially, it's member state laws that really shape action, like concrete action on biodiversity conservation. And there's also more actually competence with regards to access and benefit sharing. So the sharing of benefits arising from the use of genetic resources. Access laws, because you have sovereign rights of states, they are done at member state level. So it's national laws that determine. But then the EU took advantage of the competence they have, the little competence they have in terms of biodiversity, and they enacted a regulation which is directly applicable that essentially looks at compliance and making sure that the Nagoya Protocol is implemented at EU level in a coherent fashion, so to fight biopiracy. Then we can have like a 2-hour discussion on how efficient the Nagoya Protocol itself is and how European implementation really is efficient or not. But at least it has the merit of being there, because when you look at food and agricultural resources, genetic resources, nada, right? There's no direct EU legislation that ensures conservation or sustainable use. Everything is indirect. Okay, you have a lot of those, and they're strong legislation. So common agricultural policy, seed marketing, and the future food systems legislation, perhaps a little bit, but it's always indirect. Okay, because everything is under member states' competence with sections, so action plans on biodiversity, with sections on crop diversity. So it's always implementation of different laws. So what I was trying to get at here was that, you know, the seeds and agricultural genetic resources, I view them like as the sad little cousins or components of biodiversity conservation efforts, which are usually overshadowed by, maybe rightly, maybe wrongly, this is the thing, but it's just the finding that you can definitely say, by everything that looks at biodiversity and wild biodiversity instead of cultivated biodiversity. So do you have any questions at that stage before we attack actually? So the major indirect legislation that impacts seeds. You can raise your hand or unmute yourselves. This was just like a general kind of introduction, because you wanted to know, all of you, in the formula we circulated, you wanted to know about biodiversity conservation a lot. Can you name examples of EU members' seed laws on biodiversity? Marika. In general. So what I mentioned before in the slide before, it's essentially so action plans, you know, so it's biodiversity action plans. If you go through the documents that member states need to send to the Convention on Biological Diversity, but also to the International Treaty Secretariat. They have to say, so they have to justify how they are implementing the international treaty or the convention they signed. Okay, so that's the goal of a secretariat of an international agreement, is to check whether the countries are doing what they signed up for. And you always have like 2 to 3 questions for the CBD questionnaires, which are stronger. You have 2 to 3 questions on genetic resources, and it's very little. And you usually have like EU member states say that by having a system to register conservation varieties, they contribute to reversing the loss of crop diversity. So that's an example used usually by national member states. Another example would be like at some point, for instance, Austria had before this cap reform, but at the former, they had very strong a line, not a strong, I won't say strong. There was a line on crop diversification in the second pillar of the cap, and that was, for instance, something that was advertised as an indirect instrument that helped conserve or sustainably use biodiversity. Dylan asks me whether individual member states can make their own legislation on this matter. Is there an example of individual member states creating a better legislation? Well, they can make their own legislation, yes, definitely, on things that the EU doesn't have competence. And they're all signatories of the Convention on Biological Diversity and the international treaty. So even though they can take their own legislation, they have to abide by those instruments. Those are binding for them. So, and I mean, if they go against completely the biodiversity strategy, you know, it won't look good in Brussels, definitely. But since it's just a strategy and not a directive or a regulation, there's nothing really that the Commission can do. If they go against the Birds and Habitats Directive, then there will be infringement procedures. They can create definitely better. There's nothing standing in their way. But they can't go like against the ad minimum that exists. Okay. Matthias, are you scared for time?
Fine. Only
looking. Good. Good. But we can have maybe more questions after that when I've also talked about seed marketing, if you're still here. Up. Let's go. So the biggest chunk, obviously, of EU policy that impacts seeds is the seed marketing legislation. And it is also the legislation you wanted to know the most about. So that's why this section is quite long. And this section takes you from the history of the legislation through the new reform process that we're in today. So when you look at the history, this is a very simplified graph, but I like it because it makes you understand what where it comes from, right? So the first seed laws were enacted in the 1920s and 1930s at national level, not at European level, obviously. And please also remember what kind of political regimes were quite, strong in the 1930s in Europe, unfortunately. So, and those legislations, those laws, really wanted, so they were anchored in this notion of plant variety protection, but also to ensure the identity of a variety and to ensure the uniformity of production. So because farmers cannot know, right, what they are being sold, and there were a lot of what we call brown bagging at the time, the states said, oh, but we need to make sure, we need to protect farmers and they need to know the identity. And then obviously because of the political regimes also perhaps a little bit, and because also the dominant approach to productivity stemmed for uniformity, they said, okay, but this is how we ensure that we produce more. Okay, then we also, so this narrative got reinforced a lot because we were in stage of, so post-war, under production, so you had to boost production, and at OECD level especially, everything was picked up in the 1950s and then 60s at EU level. The idea at the OECD level was to facilitate international trade, and at EU level was to boost production, so post-World War II. And here, to boost production, it went a little beyond, so identity and uniformity. They added, so seed quality and the notion of seed lot certification. So to have certified seeds so that farmers were guaranteed to have like the best possible foundation for a productive model, right, in productivity. And then in the 1970s and 80s, the EU common seed market was created, also with the construction of the European Union itself. So I mean, maybe we could, you could see this graph like in parallel to the EU construction itself. Like we're coming from coal and steel, and then we're slowly taking a turn to a common economic community, economic community, and then European Union, right? In the 1970s, so it's all about the common catalog and the common seed market, and only, so also with the impact of international biodiversity law, from the 1990s and 2000 onwards, you have this notion that it's more than the seed market, it's more than identity, uniformity, and quality. It's also about biodiversity conservation and sustainable use, okay? And then the goal of needing to fight genetic erosion, and also having a lot of research projects that looked into farmers' populations rather than just, uniform varieties that were developed by private plant breeders, first public and then private plant breeders, all contributed to this new goal that was integrated into a legislation that is first and foremost dealing with access to the market, okay, and not biodiversity conservation. So what does it look like? So it's not an easy topic at EU level, because you have 12 directives. So these are directives of the Council and Parliament, okay? They are not directly applicable, so they need to be transposed at national level. So it means that you have 12 directives, but for each of these directives, you have 27 national legislation that transposes them in a quite a different manner, actually, so it creates a huge mess. But that's why, that's what you need to navigate today. And these 12 directives, so they're divided into crop species, and you see also perhaps a little bit the evolution. So in the 1960s, it was mostly so the first directives come with more I don't want to say cash crops, but the crops that are more important for agricultural production. And then little by little, you add things. So fruits in the 90s, so ornamentals, forest material, and vegetable propagating material other than seeds. All of these directives, obviously, they're not the same. They have not been the same since the 60s. They were amended a lot of times, and especially a big exercise was done early 2000, which is called the recast. This was before the better regulation guidelines and the refit and whatever. They codified and consolidated all of the directives because they had been amended so many times that no one really knew the obligations that they had to apply with. And so also in the I forgot to talk about this. The 1960s, 70s, they created the common catalog for cereals, so it's agricultural crop species, because it's more than cereals. So if you look back at the graph, the historical graph I showed before, so this really shows like this idea of having an EU common seed market. And also, so a common catalog for vegetables was created in 2002. It didn't exist in the 70s. So in the last leg of the graph, so this is where genetic erosion and farmers' populations, etc., come in. You have 3 commission directives. So here we're not talking about council and parliament directives. We're talking about commission directives. So these are directives that are adopted by the commission because they have been delegated the power to do so and to implement these 12 different directives in a specific way. Okay, and so that's how we come with the regime on conservation varieties for cereals, conservation and amateur varieties for vegetables, and the derogatory regime for fodder mixtures. Okay, this is the last leg of the developments, and the very, very freshest last leg is the organic regulation. Okay, so 2022. It's like it takes like 10 to 15 years for something to come. It looks, sometimes you get that feeling like this is the circle, like 10 years for something to change. Then, so and the regulation, which has, I would say 4 to 5 articles on organic seeds, and to address the need to boost the use of organic seeds and to decrease the use of derogations of whereby organic farmers use conventionally produced untreated seeds. They said, okay, we're breaching the seed marketing legislation and we're derogating the general principles of it because we need to, enlarge the offer on the market, okay, and add more heterogeneity into it. And this is where the organic heterogeneous material provisions come into play. I've talked about the principles, but let's go. So there are 3 principles in seed marketing legislation: pre-marketing registration, seed production rules, and labeling and packaging rules. For pre-marketing registration, the main idea, so in most of the directives, it would be so easy that if everything was the same for all directives, and but no, so it gets complicated. But the main principle is that you need to register your variety before you can sell the seeds of that variety, okay? And this is done through tests of distinctiveness, uniformity, stability for vegetables and vine propagating material, and through distinctiveness, uniformity, stability, to which you add this value for cultivation and use testing for agricultural crop species plus industrial chicory. Okay, and the idea here, so remember the first graph, so we're coming from a premise where you need to show the identity, to go for uniformity for productivity, and it needs to be stable also for production and productivity. Okay, they added this idea of VCU, I think 1970s, 80s, I can't recall, I'll check. And this was essentially to look not only on seeds, like in comparing them to existing varieties, but to also say, okay, you need to do better, and you can't do something just different from the others. You have to show that what you're bringing to the market is really valuable and, you know, is different from other varieties because of the properties it has, not just the size of the leaf or the, you know, the the length of the kennel, or, you know, very useful things. I mean, it could be, maybe, but not always. So this is like the main highway, okay? Pre-marketing variety registration. And these tests are done by official public authorities, okay? They cost a lot of money, and their requirements come from intellectual property rights. So the DUS protocols come from the plant variety protection legislation, whereas the VCU protocols are enacted at national level. Okay, so that's why also there's a discrepancy, and this is also something that the member states want to change. You know, some member states, not all. Then the second big way to get into this, to get access essentially to the seed market, is that you need to register before you market seeds as a supplier and provide information on the variety. Okay, so it's not a registration process completely for the variety. It's a registration process mostly for the supplier, to which you add information on the variety. And this is how fruits, ornamentals a little bit less, you have less variety information. But forest material and vegetable propagating material other than seeds work. Some of them really have less variety information requirements than others, but they really rely on, okay, if you can't trace, I don't want you to trace the variety, I don't want to create this idea of a catalog, because there's just too much on the market, especially for ornamentals. This is the argument. Then I'm just gonna check you, the operator, right? And you have to register as a professional operator. And then now you have like a third pathway, which I still put in pre-marketing registration, although it's not a registration, it's notification. But I want this to be here because maybe it should be in another color, but it's like, it's a pathway of access to the market through notification, okay? So it's a derogation to the main principle, but of variety or supplier registration, but it's just a new way to do it in a way. Then you have seed production rules. Okay, so once you've registered your variety, or you've registered yourself as a supplier, or you notified your organic heterogeneous material, you need to make sure that the seeds of the things you've registered or you've given information on have, comply with quality standards, mostly purity, germination. This is for all regulated species. And then for certain of them, you need to make sure that they're certified. Okay, so you need to certify seed lots. This is mandatory for all cereals and agricultural crops. Why didn't I just say okay? And you have a lighter regime for vegetables, which is called standard seeds, and fruit CAC material. It's optional for vine. So you also see like the major crops go through mandatory seed lot certification. And seed lot certification happens again under official control of public authorities, and means that you need to comply with a very strict rules, so isolation distances. So this is to show that what you are, so you're saying that you're producing red beets, called Balkan, let's say, and they want to make sure that you're actually producing good quality Balkan beet seeds, and that it's really Balkan beet seeds, and it's not something else, and it hasn't crossed with, Sweden beet seed, and it doesn't, change the uniformity and varietal identity of it. Okay. What happened? So in the quality standards that exist in seed production rules, you have also rules that ensure that your seeds are in good health. okay? And they don't carry pests and diseases because seeds need to be substantially free from pests. That's, I think, the language used in the Seed Marketing Directive. But now, since 2016, there's a regulation, not a directive, which ensures protection against pests and diseases, so which ensures plant health. And this also applies to seeds, not just rootstocks or trees. And the trigger of those rules is not the marketing of seeds, it's movement. Okay, it's their movement. As long as they move, they need to abide by these very strict plant health rules, which are aimed to protect plants and also users and also the biodiversity as a whole from the most harmful pests and diseases that have been identified by the European Commission and also to a certain extent member states. Okay, so the quality standards regarding seed health in the seed marketing legislation just come like on top of this very strict plant health legislation, which applies to all movement, whether you're marketing seeds or not. And then the third big principle of seed marketing legislation is labeling and packaging. It means that, you know, you've registered, you've done so the pre-marketing registration, whether it's variety or supply, you've done everything you need to do with regards to seed lot production, then now you can only sell your seeds with an official seal and an official label. So it goes without saying when you say that, you know, not only you have like 12 directives, 27 national legislation, you know, on those 12 directives, but it's also, it's a very heavy process, you know, that has really not been designed with crop diversity actors in mind. So, but what does the seed marketing legislation really apply to? Okay, so because it's not designed for crop diversity actors, the way to actually try to navigate it is also to look, how maybe it doesn't apply to what I'm doing, you know, or maybe I can, you know, escape it in a way. The first principle is that seed marketing laws only apply to listed or so-called regulated species. Okay, so you have to look at each directive or also national law, because sometimes the lists are different. You have to look in each of these instruments where you have either an annex or an article that says, this is the species that the rules apply to. For agricultural crop species, I'm sorry to tell you that most of them are listed, but you find some that are not, like there's quinoa that's not regulated, lentils are not regulated at EU level, but then you always have like the strange situation because lentils are regulated in France, you know. Asparagus is regulated at EU level, but it's not regulated in Ireland. You know, they can ask not to regulate certain species. So your idea of a EU seed, you know, common seed market, you know, gets thinner and thinner, you know, when you start to look into the seed marketing legislation a bit more in more detail. The second thing that you need to look at and to consider is that seed marketing legislation only applies to seed marketing. Okay, so you need to look and consider whether what you're doing is actually marketing. You know, and marketing is defined a bit differently across the 12 directives. Obviously, you know, if they had one definition, it would be too easy. But still, in the major ones, like so the agricultural crop species and the vegetable ones, if memory serves me well, you have one big definition that is usually used when we talk about seed marketing, and it's linked to the commercial exploitation of the seeds. Okay, and so you need to look whether what you're doing is really exploiting commercially the seeds, or whether the person you are selling it to is commercially exploiting the seeds. Okay, And so to make matters more simple, obviously you have 27 member states, and none of them really interpret this idea of commercial exploitation in the same way. You know, some actually interpreted in a very interesting fashion for crop diversity actors, like the Danish interpretation is quite relaxed on this. You have the new French law, which changed the rural code in France, which excludes the sale of seeds to amateur gardeners from the scope of seed marketing, and also it looks at exchanges of farmers as mutual aid. But you also have the countries where all exchanges of seeds, between neighbors, but also usually between farmers, they tend to view that as seed marketing. The Austrian law allows exchange and sale, but in very, very, very small amounts. Like this is the research and selection amounts that are usually, that's like par for course. You can exchange, seeds for research and selection. If you say you're doing it for that, usually you're okay. The problem is that when there are quantities that are attached to this, then, your margin of maneuver gets really small, and so depending on the country where you are at, I'm sorry, I can't give a definitive answer. If you offer seeds for sale, you have to ask, like, where am I actually selling, to whom am I selling, and in which context am I selling the seeds and propagating material. And I don't think you have you might have here in the audience very different answers to that question depending on the country, to actually say whether the seed marketing legislation applies to what you're doing or not. Very easy. Then what we have, I didn't want to go too much into detail in the legislation, but mostly show to you what can be used and has been used to promote this idea of sustainable use of biodiversity and conservation. So you have this general derogation on the material scope. So if you're not doing seed marketing, and if you're not doing conservation or sustainable use work in non-regulated species, you do not need to follow these crazy rules. Okay, so you're out of them, and you can actually focus on what you want to do, which is conserve and use sustainably seeds, right? But if you're actually considered to be doing seed marketing, or if you think, and obviously you know that there's a need to promote the sustainable use of regulated species, it's not because they're marketed across the EU that they do not need to be conserved or used sustainably. I hate that argument that comes up sometimes. Well, you can use certain derogations that exist in the legislation. And those derogations are usually so. I divide them up in two to make things simpler, is that you can have access to the common catalog and then the common seed market under adapted conditions. Okay, so this is the conservation variety system, which I noticed. So these come from Commission directives. It means that you're like, they're going to be easier on you, right? So they still use the UPOF technical questionnaires, but it's a simplified version in some countries. In others, it's actually the full one. And you can sell, they will just not control it the same way. It also depends on the country, because in the Netherlands, they take conservation varieties for official testing. In most EU countries, they don't. Honestly, at least you skip that stage. You don't need to pay the many fees and to go through the administrative process of variety registration. So in the major crop species, this is only for agricultural crops and for vegetables. For vegetables, there's also something called amateur variety, right? For conservation varieties, it's about land races that are at risk of genetic erosion, and amateur varieties are for they're not valued for commercial crop production, but they have another intrinsic value. I kid you not, this is the language of the legislation. Okay. It just means that you have adapted access to the official catalog. It comes with a lot of conditions, though. You cannot market the seeds of these varieties as you wish. You still need to certify your seeds when you're selling seeds of cereal and agricultural crop varieties, conservation varieties, not for veg, because that's exception exists for all vegetable seeds. But for conservation varieties, you also have quantity limits. And for amateur varieties, you can only sell in small packages. Another big derogation that came like 1 year ago, but was negotiated for much longer, is the notification system of organic heterogeneous material. Here, there is no variety registration process. It's a notification. It's based on a dossier. It has no links to intellectual property rights. Okay, it's based on a description of the characteristics. So you need to show different things. You need to say where the material was produced, etc. There are technical terms there, but still it's not linked to the official variety registration route that exists in the seed marketing legislation. And you can also market it without certifying seeds. So the entire thing is much less heavy if you want to. So if what you're doing is considered to be seed marketing, and if you're doing it in regulated species, it's much less burdensome. But yeah, still, I mean, this is a tool to access the market, and it always feels odd to me to describe these mechanism as a mechanism to conserve biodiversity when we're talking about seed marketing. This is it's something else. Then you have derogations also on production and labeling rules. Okay, so you don't have to use an official label for small packages. You can rely on a supplier's label, and there's this idea of non-certified seeds for heterogeneous material, and then you have the standard seeds for vegetables and the CAC material for fruits, where you essentially escape this very heavy seed lot certification process. Okay, but so this is the space that is given in a way for sustainable use. So it's like tree bubbles, very difficult to navigate, and which depends a lot from one member state to another, the way also it impacts you and the margin of maneuver you have. Knowing this, right, because the Commission also knows that everything is way too complicated. Okay, so the institutions know, it's not like a secret that this legislation is just way too complex. They don't want to pay lawyers either. It's not necessarily their goal. So a reform process, like a huge reform process, was already started after the main recast and codification exercise they did in 2008. Maybe they realized even more when they saw everything, like, no, that this needs to change. No. So they started by doing a study, so through an external contractor. So it's a consortium. They did 2 studies, one which was generally evaluating the legislation, another which looked more specifically on the procedure of variety registration. So this was in 2008 and 2010. Then in 2011, the European Commission formally came in and presented options, a paper, and a staff working document with having public consultation. So this is like the general good lawmaking principles of the European Commission that we saw in Lab 1. And then they did an impact assessment, in 2012. The entire thing was quite delayed because there was a lawsuit that opposed in France a seed company called Graines Beaumont and the French association Cocopelli, where Graines Beaumont was accusing Cocopelli of unfair competition because they were selling seeds of varieties that weren't registered. Okay, so in this entire this entire process, and that went all the way to the European Court of Justice, delayed the impact assessment of the European Commission. But at the end of the day, so in May 2013, the Commission comes with a proposal for a regulation. So they wanted to replace 12 directives that need to be transposed in national legislation by a regulation. Okay, so that would mean, so you created, they still had this idea in 1970s, 80s. The idea is to create a EU common market, right? So if you have a regulation, you have uniform application. There's like, how do you call that? There's more level playing field, so everyone plays by the same rules, but it also means you lose a lot of flexibility in different countries, okay? In the states, lose flexibility. What they proposed with regards to seed marketing was that there was no more link to commercial exploitation of seeds, but they were referring to making available on the market, which is so much worse, because make available can be like interpreted in so many other ways. Like they had cut down the link between the seed marketing legislation and commerce, and what is the market? Everything can be a market. We live in such a society, so it was a very broad definition that could encompass a lot of things. And you had like a second article where there were exceptions, like this is not viewed like making available on the market, only if you are doing so. There's breeding selection, usually that's out, but conservation, but in networks and in a very weird formulation, and exchange between non-professionals. Okay, so if you're an amateur gardener, you could have exchanged seeds that wouldn't have been making available on the market, but two farmers exchanging seeds, that's making available on the market, even if the person is your neighbor, you're helping out, that's making it available on the market. So that was the definition of seed marketing. So already an extremely extensive scope, if you wish. With regards to regulated species, so there was an annex to the regulation that could be amended by the Commission through a Commission regulation, because there was a delegation of power there. And there was also in what is called the Basic Act, so the regulation of Council and Parliament, there were formal criteria to have a species regulated. And those were, so the area of production in the EU had to be high, the value had to be high, or you could have a high number of operators. So something could have been like little value, but just because you have like 2,000, I don't know, seed savers that are interested in something because it has a different meaning than just a market meaning, then it could have actually be considered as a regulated species. So that was the proposal for regulated species. The principle of registration didn't change, just that it became mandatory for all operators and also for all crop species. So even the things where you had, the derogations, you remember maybe when you look back, so you look at the principle of variety registration, you had like 3 entry points, right? And for ornamentals, for instance, this regulation would have changed it completely drastically, because it would have shifted entirely the system that exists today. And having mandatory registration for all operators, you don't have that in quite a number of, important directives currently, so, and it could have meant that all seed savers would have been registered, so it didn't change the principle, but it actually applied it to a wide range of users and a wide range of species. What it also did, is that you remained obviously linked to the criteria of distinctiveness, uniformity, stability that come from intellectual property rights, to which they added, like, oh, we're in the 21st century, we need to do something, Then they said, okay, but this additional species that are of particular agricultural importance, potentially also vegetables, I don't think it's that clear inside. We're going to test the value of cultivation and use environmentally, so we're environmentally cautious, we want to really make sure that what you put on the market, is really useful, brings an added value to the system. This also meant that, and the VCU testing also means, you can be for or against, it means that actually it becomes more difficult to register a variety in order to market the seeds than it is difficult to get an intellectual property right, which is a monopoly, like an artificial monopoly, over a variety, because for that intellectual property right, so for the monopoly, plant breeders' rights, they only look for the US, right? So for agricultural crop species, even today, it's actually more difficult to have access to the market than to get an intellectual property right title, which, when you say it out loud, it really makes little sense. Then you have derogations, okay, like today. But the derogations were reshuffled a bit. They were probably written at very last minute because they were really like it wasn't it wasn't a coherent lot. Maybe in someone's head they were. But so you didn't have the conservation variety regime like you do today. That was replaced into like 3 types of derogations. You had one for heterogeneous material, not just organic, heterogeneous material. So this is before the organic regulation now. And for that, the article is quite little and short. The only thing that that is that it's not a variety. It's heterogeneous in its characteristics. It could have been sold as standard seeds, and all of the real details of the regime and the definition of the material, etc., and how it's going to be marketed, everything would have been defined in a commission delegated act. So nothing essentially was going to be decided by the council and parliament, which, may I remind you from the last lab, are the co-legislators at European level, but everything was going to be decided by the Commission, with obviously the consultation of member state experts, but very little European Parliament engagement, right? Then you had the second derogation, which is niche market material, and that material is a variety. It could have been a variety, but it could only have been sold in small quantities by micro enterprises or by non-professionals, so amateur gardeners, seed savers. You could do it by selling standard seeds, but again, the details would have been defined in Commission Delegated Act. Okay, so it wasn't clear. Again, there were a lot of things that were left to the Commission to decide upon later on. And then a third derogation, so this was, I guess, the thing that resembles the current conservation variety regime the most. It's the varieties with official description. And it was foreseen for land races, mostly in deleted varieties, and probably would have been sold only in region of origin, although it's not clear. And again, details in delegated acts. But you had a little more information on varieties with official description and niche market material than heterogeneous material, but still everything was to be decided. Like the most important procedural points would have been decided afterwards in Commission regulations. So what happened? Sorry, for seed production, the idea was mandatory seed lot certification. However, they had exceptions for standard seed for all species, only as a derogatory regime. So the three things I mentioned, so heterogeneous material, niche markets, and officially recognized description. And it had to be proportionate. And if memory serves me well, the Commission also had the power to adopt a list of species where you could just not sell standard seed because they were too important for the agricultural crop production. Okay. So again, a lot of certainty. Then labeling and packaging. So the idea of an official label continued, but this idea of this operator's label, so what's also a supplier's label for small packages in, I think, the fruit directive, was given to everything because, so all species, because the regulation proposal had like one of the cornerstones and principles of it was this idea of having controls over under official supervision. Okay, because as you can imagine, this entire system costs a lot of money to public authorities who need to test the varieties, they need to cultivate them, they need to look whether they're different as their reference collections of all varieties. They need to maintain those reference collections, etc. So it costs a lot of money, not just for seed operators, but it also costs a lot of money to public authorities, right? And the idea was to make sure that so the entire system didn't drain that much public finances, but that operators who were authorized by public authorities to do the controls and would be checked by the public authorities and would do the tests themselves, but with the control and supervision of public authorities. Okay. You also still had on labeling and packaging the entire idea that for small packages, you have to derogate, like you can't have the same labeling and packaging rules for like small seed packages and like tons, right? So that's like common sense. So what happened? Now the file, so that's the file at the hand of the European Commission. We changed logo, so we're at the European Parliament. So at the European Parliament, the rapporteur was selected in the Agri Committee. So the Agri Committee, Agriculture and Rural Development Committee, was designated as the competent committee within the European Parliament, and the rapporteur was designated. That rapporteur came from the European People's Party, so Christian Democrats, and he worked on the proposal and proposed amendments. And he said in his amendments, there were not a lot. I don't remember the exact number, but compared to other files, and especially so these past legislature, it wasn't an incredibly high number of amendments proposed by the rapporteur, but he still said that the proposal was not sufficiently clear, especially on the three derogations. There was more simplification needed in variety registration procedures. It should be limited to micro enterprises. There were too many delegated acts. You had a lot more, but I picked the ones maybe who were more interesting for crop diversity actors. Then, so the other members of the European Parliament who are part of the Agri Committee started to submit amendments, and the Environment Committee also gave its opinion, and the rapporteur of the Environment Committee was again a Christian Democrat. This is Pilar Ayuso, I think from Spain. And the committee proposed actually rejection of the proposal, because the overall objective of the legislation should include the facilitation and encouragement of biodiversity maintenance in agriculture and horticulture. And the members of the Environment Committee did not see that objective in the legislation proposal, the regulation proposal. And that the proposal had this one-size-fits-all approach that was just too narrow, and there were too many delegated acts, and there were concerns over forest material, because I didn't talk about this, but the legislation also has an entire pan on forest material, which will be dealt, I think, separately this time around. I think got their lesson on this. And also for ornamentals and sale to home gardeners. And that the committee was also concerned that there were too many powers granted to private actors in the Community Plant Variety Office, which is the CPVO. The Agri report, then the MEPs also tabled amendments, but after the environment opinion, sorry, the Agri committee also requested the Parliament plenary to reject the proposal, and the rejection was confirmed in a plenary vote. This never happened before. Okay, so it was quite a big deal. It was also prior to elections, etc. And then in March 2014, the proposal was withdrawn by the European Commission, and they didn't want to touch it. But, you know, we're breaking my cycle of 10 years because, but I mean, honestly, I think the cycle of 10 years would have continued if the council, so the member states, had not requested the European Commission to actually do a study on options to reform the EU seed marketing rules. So 5 years after the rejection, they still, you know, they had to work on the file, and the Commission was quite reluctant to do it. But they did a study. Well, they commissioned a private consultancy to do the study, and the study had interviews with stakeholders. They had surveys, I think, and there was an entire section that was focused on amateur gardeners. Everything is online, so you can have access to it if you're interested. It's quite long. And then there's the Commission staff working document that is attached to that was published. So a little after, so a few months after the study was published, was done. And the legislation was considered by the European Commission to be unfit for the European Green Deal and the Farm to Fork, and that you needed to facilitate the registration of traditional varieties, ensure a level playing field, adapt to technological developments and innovation. Okay, so woohoo, reform kicked off, like breaking the cycle 6 years after rejection, right? June 2021, there's an inception impact assessment published again by the Commission, and where they assessed those. So they identified 3 options for reform plus a baseline, so do nothing option, that they need to put there just because they need to assess the impacts of the options they present compared to the baseline, so no change. And then, so 2021, 2022, they did a study which looked at impacts, not just on options like they did in 2019. This time it was really on impacts, again by the same external contractor. And here, so you have a lot of rules that need to be followed. I mentioned them a little bit, the first lab. So the better regulation guidelines, they have to look at the different socioeconomic impacts, the human rights impacts, the environmental impacts of each policy option. And then they have to come up with a proposal. Right now, they're stuck in this. Okay, so because what they have, like the Commission has as a problem, is that the study of the external contractor didn't conclude, I think wasn't clear enough in its conclusions to show that one policy option was better than the other. And so right now they're mixing up a bit what they had initially foreseen to see where there's terrain for compromise. And that's why the proposal was expected December this year, like now. And it has been postponed to probably May or spring 2023. No one knows. I can't. Yeah, I'm not Nostradamus, but that's the plan. So it's spring 2023, and it's unclear whether they will formally propose a regulation or a directive. I think they would favor a regulation because of this idea of the common EU seed market that stems from the 1970s. But I think it was quite open, and especially now that they're juggling around with the different policy options, who knows? And then once the proposal of the Commission is published, then it goes to the heads of the two co-legislators, so the European Council and the Parliament, and the negotiation starts in the committees of the European Parliament and the Special Committee on Agriculture, Working Group Genetic Resources of the Council. That's it for seed marketing. I know it's a lot.
Maybe, Fulia, there are a few questions that you can pick quite at the moment.
In the chat, wait.
Yeah. Because we have the problem that panelists cannot write in the Q&A part. So we need to from the chat and not from the... So the first one is from Susan. Which member state made the...
Wait, no, I go back because it's going to follow,
Yeah.
I need to follow the... so there's one on patents that I'll do after. Dylan says, notification is important as there are high risk that national authorities misunderstand. Okay. Yes, indeed. Words are important. What is available in English? I don't know. Claudia?
The OHM.
Maybe.
It's sold.
What is OHM again? Organic heterogeneous material. The Danish thing is available in English. Sorry. It would be maybe easier if you raised your hand and asked me the question. Since lentils are not regulated from Basso, are we free to sell traditional varieties of lentils without? Yes. Just look at be sure that it's not on the Greek list, but I don't think it is. But yeah, if it's not, you only have to abide by plant health rules because you're going to officially be moving seeds. And for plant health rules, I don't think there's any pests that have been identified as, where lentil seeds have been identified as a vector of the circulation of pests and diseases. So yeah, you are free to do what you want. Why is France allowed to regulate lentils? Because all of them are allowed to do, like they go through a procedure. It's like, why is Ireland allowed to deregulate asparagus? They have this member state group, expert group, where they discuss the species that they would like to regulate additionally or deregulate, and it goes through the process. The member states present their arguments and it passes through or it doesn't. Since it's a very non-transparent process, I don't know how, if there are examples of species which were proposed by member states, to be regulated or deregulated that were opposed by other countries. So yeah, unless you have little spy at the expert group, I can't help you. What means VCU? So it's value for cultivation and use. Yes. And okay. How it is decided that a variety should be withdrawn from the catalog? Oh yeah, I didn't talk about maintenance and withdrawal because I didn't want to confuse a lot of people. Varieties that are registered also need to be maintained. So you need to appoint someone who maintains the variety as is, so that it's always available to be marketed. And the withdrawal, it can be decided by the person who registers unilaterally, and it can also be decided by public authorities because they realize that, you know, it infringes on something. For instance, like they haven't noticed, in like example, they haven't noticed when they were doing the controls that it was actually something else, like that it, I don't know, it was you know, they said it was Japanese cauliflower, but they realized that it was Chinese cauliflower that was also already marketed somewhere, you know, in Europe or something. If they make a mistake or they see fraud, then the public authorities will withdraw. Or if they, for instance, like I'm going to open a can of worms, but they see that it's GM, they'll withdraw because you haven't followed the process. The derogations for conservation amateur varieties have been discussed. The German office is strict and difficult. Yes, this is what I said. Which member states made the council suggest the study? Council votes are not public on these things, so we don't know. Who decides and how, who the rapporteur is. This is in lab 1. I explained it a little bit. So the rapporteur is elected within the committee itself, but it's a negotiation between political groups, the coordinators of those political groups. It's, yeah. So it's the members of the European Parliament themselves, plus the heads of the political groups, de facto in a way a little bit, who negotiate which member of parliament gets the rapporteurship. Who is the contractor that made the assessment? The ICF. What are your impressions about the assessment? Once we stop recording. In German, the law uses the same term for maintenance and conservation. Erhaltung. Yeah. I think I've gone through the question. Yeah. Good. Oh, we only have 10 minutes left, right? But I'll be quick on intellectual property rights. Or do you want me to finish to do the intellectual property rights on Friday? And so we discuss more, or is everyone able to come on Friday so we can have a more Q&A session and discussion on Friday? What do you think, Matthias, and the others?
Maybe people can express what they prefer better now. So Dylan, and yeah,
so
maybe we can go. Yeah, maybe we continue. Maybe you can cut a bit and then.
Yeah,
maybe...
it's short anyway.
Okay.
Okay, so deep dive. It's 3 slides. So you have different types of intellectual property rights in legislation in general, not just seeds. So there are the intellectual property rights that are attached to creativity. So that's copyright of, for instance, these slides. I don't believe in copyright, so you can do whatever you want with it. You also have those who protect brands and the names of something. So it's a trademark. You have those that honor agricultural products or traditions. Those are geographical indications. And you have those who foster innovation in theory. And those are for seeds, plant variety rights, and patents. You also have designs and things like this, but I won't get. But these are like the 4 things, the 4 types of property rights that are giving on intangible things. Okay, it's intellectual property rights because it's not on something you can touch. Okay, although you can argue that seeds can be touched, but the property is on the variety, not the seed, which is like, yeah, the law, right? So what does it mean? For your one example is a tomato. What kind of unseen, like invisible rights can come with this tomato? You have plant variety protection. So that's the protection of the phenotype. So it's the plant variety as a whole. And here in this case, in the case of Kumato, we know it's open and public. You have 2 protected plant varieties that are used and then sold as Kumato. As a result, you would need the Syngenta's consent to use the protected variety outside of the breeders and farmers privilege. So outside of the things you're allowed to do. There's a list of actions where you need the consent of the plant variety protection holder that you cannot do without their consent. Okay, the idea of intellectual property rights is to give you exclusive rights over something for a certain period of time, and so you can exclude others and say, nah, I'm not giving you the right to do whatever you want with this. Or they say, you pay me, you can do whatever you want, but you pay me. Okay, and that's how the idea being that you foster innovation, because you put these people who are doing inventive things, you give them a monopoly and you give them an advantage in the market. Okay, that's the general idea. But on this same Kumato, you can also have patents, which are on genotypes. So it's usually on genetic resources or on processes that are non-essentially biological. I'm not going to make you sweat this, but it's hypothetical. So you could have patents in there. You won't know if there's a patent or not, but you would, if there's a patent, you need, again, Syngenta's consent to use the variety for acts that are listed in national laws, in patent laws. And that obviously includes production, reproduction, multiplication, like plant variety protection. For you also have, in this case, a trademark. So the name Kumato is trademarked. You see the little TM here. And you would need Syngenta's consent to use the name Kumato on tomatoes. So you cannot market anything, like not anything, but it's linked to a code in the codex. So you cannot market tomatoes with the name Kumato because it's a registered trademark of Syngenta. You can call them Mukato. That's open game, okay? But no Kumato. And so what happened in the European Green Deal here? There is an action plan on intellectual property that came not in May 2020, but in November 2020. And it says that they needed to update IP protection, so roll out the unitary patent system, strengthen geographical indications, improve the system for protection of plant varieties. And they state clearly that there is a targeted reform of plant variety protection at EU level that's coming and probably will start in 2023. And I think it's in the work program of the European Commission. Haven't checked, but there's they call it a targeted reform, so it won't be substantial, but who knows what that means. My last slide is maybe to have a different kind of take on all of this. Okay, so maybe something that makes more sense to you, or a different way of looking at the law of the seeds, is to adopt a human rights perspective. Maybe it's a bit anthropocentric, definitely it is, rather than the biodiversity conservation take that I started this presentation from. But I think it's a very useful way of looking at things, and it's a holistic approach that I think might not at the end be that anthropocentric. It's so the declaration that came from the United Nations General Assembly on the rights of peasants and other people living working in rural areas of the 28th of September 2018. Okay, it's a United Nations human rights declaration. It's not an international treaty of human rights, but it is a tool to interpret existing human rights legislation and international legislative instruments. So it has an indirect but quite strong effects on the law of the seeds. And what does the declaration say? So it has a full-on article on the rights to seed. It addresses also the right to land, right to water, social security, etc. So it's a very, I mean, read it through if you have time one day. It's a really interesting text. But for seeds, so it foresees different elements. There's the right to save, use, exchange, sell their own seeds, so peasants' own seeds, the right to maintain, control, develop their own seeds, right to have access to locally adapted seed, right to participate in decision-making, right to the protection of traditional knowledge, and the sharing of benefits. So like you saw the first slides on international law. So these are all like, they were formulated as state obligations in the Convention on Biological Diversity, the international treaty. Some wording also comes from the Declaration on Indigenous Peoples' Rights, like also come from the covenants, or the International Covenants on Social and Economic Rights. But at the end of the day here, it's all about rights. And then you have state obligations to respect, protect, and fulfill those rights, and to support peasant seed systems, and to promote the use of peasant seeds and agrobiodiversity, ensure participation of peasants in decision-making. I think it's just a different way that might be useful to look at things and to use when you talk about the law of the seed, which usually is something that's quite, you know, slow and not slow, but cold in a way, and not the most, you know, easy to understand. You know.